Hi everyone, today we'll be doing conflict of laws. So first of all, let me give you a brief introduction about what is conflict of laws. Conflict of laws, also known as private international law, spans across different legal jurisdictions, different persons, companies and other legal entities. So here it's about selection of the appropriate legal system to govern dispute with an international element in it. So here there are three main areas which we need to consider. The first one is jurisdiction, the second one is choice of law, and the third one is recognition and enforcement of foreign judgments. First of all, let me discuss about jurisdiction. So there are two types in this case. So the first one is jurisdiction in personam, which is judgments made over a person, and jurisdiction in rem, which are judgments made over physical things, which is ships or relating to admiralty law. So there are 4 steps relating to enforcement of foreign judgments. So the first one is characterization of the dispute. First of all, we need to characterize whether this dispute related to tort, contracts, family matters, succession. First we need to understand what is the issue. The second one is to find which court has the jurisdiction. And the third step is to select the law of the legal system applicable to the dispute, considering the factors depending on the situation. And the fourth step is applying the law on expert evidence. So here we only apply the substantive law. So the burden of proof falls on the person who seeks to rely on it. So he needs to establish sufficient evidence in this case. Now, let's move on to the first and the most important chapter in conflict of laws. That is the topic of domicile. Here, domicile means a permanent home. It's not the actual home, but it's a link between a person and a place. So, domicile is a status or an attribution of being a lawful permanent resident in a particular jurisdiction. Here, a person can remain domicile in a jurisdiction even after he has left that jurisdiction, but if he has maintained sufficient link with that jurisdiction, and of course, and at the same time he has not displayed any intention to abandon it permanently. Here, domicile could be a country which he has never been, but once the domicile is ascertained, it's a connecting factor to establish lex causa. So there are 3 types of domiciles. One is the domicile of dependence, domicile of origin, and domicile of choice. Now, there are few principles that we need to understand before going into the deeper content. Here, no one can live without a domicile, and one person cannot have more than one domicile at a time. But there are statutory exceptions to this matter. But the burden of proof falls on the person who asserts to change the domicile. Now, let's move into the first subtopic in domicile, which is domicile of dependence. Here, it's basically the father's domicile. So, it's the father's domicile that goes to his children. So, here, for a married woman, if you consider a married woman, so her domicile will become his husband's home. Her husband's domicile will become her domicile once they get married. So regardless of her intentions and regardless whether she lives with him or not, and if they are judicially separated but not divorced, the husband's domicile will be applied. For children, it's the father's domicile. It's only for legitimate children, not for illegitimate. For illegitimate children, it's the mother's domicile. For the children who are abdicated, then it's not the father's domicile. But there might be instances for what will happen for legitimated children, they were born illegitimate, but once they were legitimated, then the father's domicile will follow. Now let's move into domicile of choice. In this, there are few characterizations that we can see from this topic, which is a person who is 16 years of age or above, married, and who is not insane can acquire the domicile of choice. So there are 2 requirements which need to be fulfilled in order to acquire domicile of choice. And the first one is the person who intends to acquire domicile of choice should take up residence in the new place, acquire the new place with the intention of remaining there permanently. Here, the residence to establish, it's not necessary to establish residence of length, but a residence acquires with the intention to settle is enough. So let's look into some case law where we can understand how this concept proceeded through these ages. So it's Bell versus Kennedy, 1868. So Mr. Bell left his domicile of origin in Jamaica for good and acquired a new residence in Scotland. But he could not make up his mind to live in Scotland. But he was in doubt whether he should return to Jamaica or live in Scotland and continue his new home. But he continued his new home in Scotland. Later, his wife passed away, and after some years, Mr. Bell bought an estate in Scotland. So in the court, it was held that Mrs. Bell's domicile was Jamaica, while Mr. Bell's domicile was in Scotland, because by the time Mr. Bell bought the estate in Jamaica, his wife, by the time he was bought in Jamaica, his wife didn't acquire the domicile of Scotland. And Mr. Bell's domicile is in Scotland because he had acquired domicile prior to his death. Accordingly, to acquire domicile, the clear intention to reside at that place is essential. So there can be a question, can a person hold two domiciles at the same time? But in this case, we need to prove that one domicile is the chief domicile of that person. So there's this another case, which is Plummer versus IRC. So it talks about two domiciles. In this case, Elizabeth Plummer was born in England and her domicile of origin was in England. She was living with her mother, father, sister in London. Years later, her mother and sister moved to Guernsey. But Elizabeth stayed with her father in London for educational purposes. But she had this intention to return to Guernsey while her education was done. Her passport and her bank accounts carried both the addresses of Guernsey and in London. But in this case, the court held it's not possible to acquire a new domicile of choice without ceasing to be resident in domicile of origin, but has to be established that residence in the new place is the chief residence. So that's another fact that we should understand while we're going through this domicile topic. One is, immigrants get the domicile of new country as soon as they step into the new country. It doesn't matter whether they rent or buy a house, but as soon as they step into the new country, that will become their domicile. For illegal immigrants, this won't be subjected. And here, the most important factor is intention. So intention to reside could be varied for a definite period and leave, so it is not sufficient. Until a definite purpose is achieved, which is also not sufficient to acquire domicile. To reside for an indefinite period, generally domicile won't be granted under that circumstances. So this is the only chance that he can get that he can acquire the domicile is in situations where he has the intention to reside forever for what will happen. So he's not certain, he have to be certain, but if something happens, then there's no choice but to leave. So there's this case called Winans versus AG. So in this case, Winans was an American millionaire who hated England but stayed in England for 37 years for medical purposes. So he had this idea of building a fleet of ships and sailing in England seas carrying the American flag. So which means his mind was totally in America. So this prevented him from acquiring domicile in England. So through this case, we can understand that long residence alone is not sufficient to acquire domicile. So there's this another case called RIC versus Bullock. So in this case, a person lived in England for 40 years and yet he didn't acquire domicile in England because he was hoping to return to Canada when his wife died. So he had the intention to return to Canada. So that's why he didn't acquire the domicile in England. So there can be two ways of proving the intention. So here there are direct evidence and indirect evidence. So direct evidence are the statements made by the person himself, but at the same time they can be self-serving. They can be self-serving, may not be reliable, but if he is totally depending on his statements, they should be backed with solid evidence. And the other one is indirect evidence. So they are consideration of all circumstances in his life. So, can the domicile be abandoned? Yes, it can be abandoned, but there are situations which it cannot be abandoned. So, one is if there's an intention to return, so the domicile won't be abandoned. Then the next is decided to leave but hasn't left, then you won't lose your domicile. So, let's go to another case, that is Goods of Raphael case. There was a woman who had a domicile of origin in England, so she acquired a domicile in France by marriage. After her husband's death, she decided to return to England. Unfortunately, she died as she was about to board into the Channel steamer. The court held she did not acquire domicile, but she did not acquire domicile of England because she had not abandoned her French domicile. So there is another case called Ray Jones Estate. It's like more similar case, but it's better you all know as much as cases. Domicile of origin was Wales. He immigrated to USA, acquired a property and domicile of choice in Iowa. So his wife died, so he decided to return to Wales, but the ship sank and this person died. So according to English law, domicile of origin was Wales, but according to American law, it was Iowa. So there are differences in both legal systems. So that's the importance of learning conflict of laws. So there are special cases related to prisoners, refugees, and soldiers. For prisoners, if they're like exiled for life, then their domicile will become the prison's domicile. Then for refugees, if they intend to return, and then they have not abandoned their homeland. For soldiers, it depends on the circumstances. So now let's move into domicile of origin. Here, everyone has domicile of origin. It cannot be lost. But like if parents' domicile is unknown, then where the country the child was found will eventually become the domicile of the child. Domicile of origin can't be abandoned or left aside, but if no other domicile is applicable, domicile of origin will revert. Once the domicile of origin is fixed, it cannot be changed like domicile of dependence or domicile of choice. So, however, adoptive children can acquire the adoptive father's domicile. So it's not frequently inoperative and it is not used as a connecting factor to establish lex causa. So there can be a question for you all, that can domicile of origin be discarded? Domicile of origin is difficult to be discarded. The party intending to discard the domicile of origin must establish cessation of lawful presence and intention not to return. The newly acquired domicile also requires presence and intention to remain indefinitely. So that is special case called Johnson and Johnson. So it says Johnson was a mid-aged Swedish sailor who wanted to travel around the world. Therefore, he started traveling to various countries and he spent short periods in Sweden. So when he returned to USA, he seemed to be settled in New Jersey, but wished to move to any other part to better his prospects. So he got married in New York. So in this case, the issue was, what was his domicile at the time of his marriage? So it was held that Sweden was his domicile, but because he didn't have a clear intention not to return to Sweden. So let me take you to another one important aspect in this chapter of domicile, which is incorporation of companies. So here, the domicile in a place of incorporation cannot be changed even if it carries the business elsewhere. So here, there are like several critiques to this concept of domicile. The one is it's difficult to tell where the person is from, and it's not easy to establish. It's pretty expensive, and a person can come up with all artificial domiciles with no real links. So those are the critics that are there for domicile. It is like more criticized area, but once you understand it and like once you see the importance relating to international law, it plays a major role. So there's habitual residence and nationality. So in this case, some legal systems adopt these instead of domicile. So habitual residence is, it's about regular physical presence which must endure for some time but did not require the same intention necessary to acquire domicile. In domicile, intention plays a major role, but in this case it doesn't. Thus, the habitual residence can continue even after absentee for longer periods. So, habitual residence is something less than domicile but more than simple residence. So, it may also be more discriminating than nationality. So, nationality is like a legal relationship between a person and a state. So, nationality affords the state jurisdiction and the protection of the state to that individual. So, the rights and the duties are protected and it's provided as well. Concept of nationality is a political concept. Keep that in mind. It's a political concept, and there are people with dual nationality and more than one country, or have nationality in more than one country, so which is used in civil law countries. So this is a small explanation about domicile, and I hope it's enough for you all to face the exam in this particular chapter. It's better you all go through past papers and all the case law. Hope this was useful. Thank you.